Good morning, everyone, and welcome back to our weekly webinar series. We continue to discuss the discussion papers from IBBI today and hope that we get questions and comments, suggestions on the IBBI discussion papers so that we can all understanding on what needs to be changed in the discussion papers or based on the discussion papers, and we can give proper feedback to IBBI. So over to Anil, sir.
Thank you, Ankit. Welcome to all the participants to 84th episode of AAA Weekly Webinar Series. This episode is almost in continuation of our last episode where we discussed the discussion papers released by IBBI seeking comments from all stakeholders. So giving comments is very, very important now rather than cribbing later or complaining later. So in case all of us join together and give our comments, I believe it will have impact. So we would expect some kind of emails or some on this particular program in case some comments or some kind of advice is given. That would really be appreciable for the profession. Secondly, the last dates for giving our comments are approaching. We should give our comments online on the portal of IBBI. Just sparing about 15-20 minutes would actually help a better implementation of all these proposed amendments. So we have also added the discussion on the real estate proposals and some judgments also, some of the recent judgments that we have added pertaining to real estate. So that actually will also give some clarity why these changes are proposed. So just continuing, and I'll just share my screen. So we are discussing today the real estate related proposals. Those would be basically in two separate regulations. One would be amendment in CIRP regulations and the other would be amendment in liquidation regulations. This discussion paper was released on 6th November and our last date for giving our comments is approaching very fast. The primary objectives of this discussion paper was to ensure more transparent, accountable and efficient process for real estate companies, smoother handover of units to real estate allottees under CIRP. So basically giving powers to the RP for handing over the possession of the units of the allottees. Expedite the resolution process and to avoid delays in the expedite the resolution process and avoid delays in unnecessary held-ups. The reference to 𝐝𝐬𝐬𝐜𝐸 committee has also been given in this discussion paper, and according to this discussion paper, probably IBBI has done its part as recommended by 𝐝𝐬𝐬𝐜𝐸 committee on real estate projects. So that committee, in fact, had given a report, and in fact, overall, the report of the committee was that the IBC needs to be reformed to better accommodate the complexity of real estate cases. IBC was proactive. They have taken a very, very timely step. So the recommendations from the 𝐝𝐬𝐬𝐜𝐸 committee has also been taken in the discussion paper. The first recommendation was the project-wise CIRP. So, and also the registration of project under RERA as each project, because the RERA recognizes real estate as a project, not as a company. So the RERA concept is being copied here in the real estate, in the insolvency, that the insolvency can also start project-wise and not the company-wise. So, and the registration of the RERA project is a must. The RP is advised to work along with the RERA and comply with all the compliances which are required under RERA. Second issue was the transfer of ownership possession to the allottees. So this was also the suggestions of 𝐝𝐬𝐬𝐜𝐸𝐸 committee, that with the approval of the committee of creditors, the RP or the IRP should be empowered to transfer the ownership and possession of the plot, apartment, building, unit to the allottees in the resolution during the resolution process, because there was a controversy whether Section 14 is applicable on transfer of ownership or not. So it has been held by some courts that Section 14 is not applicable to inventory, because see, these are not assets of the company, these are the inventory of the company. So Section 14 is not applicable on inventory. So the inventory can be sold, can be transferred, and the title of the inventory can also be transferred. So all these units, plots, apartments are inventory for a real estate company. The option also may be given to the allottees where they actually can buy as is, where is basis. I mean, that is applicable only where the full structure has been completed and some of the common facilities have also been made, but the internal fittings and the interiors are pending. So that option should also be given to the resolution to the allottees, that in case somebody is interested in taking over as is, where is basis, that should be taken over. That should be done. Then is the registration of the transfer of the ownership where the possession is transferred. Now, there are many cases where the possession has been transferred to allottees. In some of the cases, even the agreements have also been registered. Power of attorney have also been given. And why the ownership is not being transferred? Because there is a requirement of seeking NOC from the lenders. So that particular NOC is not available. So the possession is available, but then the ownership is not available. So allottees are suffering. They are not able to transact. They are not able to further create a security interest to their lenders who have given home loan. So they are suffering higher interest rate, and they are also not able to exit from this particular investment in case they are not willing to live here. So this is also one of the suggestions of the Amitabh Kant committee. And then further, there was a colloquium on functioning of the strengthening of the IBC. That colloquium, in fact, was held in November 22. I also attended that colloquium. Huge discussion have happened in that colloquium also regarding the real estate cases. And the recommendations in that colloquium report was also kind of similar to Amitabh Kant committee report. The rationale that had been given, that rationale was given that the project-wise admission should be facilitated, project-wise resolution should be facilitated, delivery of completed houses, completed units should be given to the home buyers, allowing home buyers to become resolution applicant. So these were some of the suggestions. And the rationale given in that particular suggestion was that the large number of real estate cases have remained unresolved for years. And therefore, the CIRP is not conducive to address issues regarding the real estate. So in the real estate companies, there are many CD. The CD has multiple projects. In some of the projects which are very close to completion, there are some people who are interested, some resolution applicant are interested. But in some of the projects which are at initial stages, no one is interested. So therefore, it was proposed that project-wise resolution plan may be invited. Project-wise insolvency may be initiated. So this was also the suggestions given by the colloquium on functioning of strengthening of the IBC ecosystem that was held in November 22. Based on these two, based on the other feedback received by the IBBI, now there are 4 specific areas where the amendments are proposed. One is the mandatory registration and extension of project registration under RERA. Operating a separate bank account for each real estate project. Execution of registration or sublease deed with approval of the committee of the creditors during CIRP. COC to examine and invite separate plans for each project, and exclusion of property in possession of the home buyers from the liquidation estate. So these are the 5 areas where the proposals have been made public for the opinion. Going each one by one, first of all, we'll take up these 2 first. Mandatory registration and extension of project registration under RERA. So the section 3 of the RERA, in fact, stipulates that in case the total unit exceeds 8 and the total the land on which the units are constructed exceeds 500 square meter, then it would require RERA registration. So in case of less than 500 square meter or less than 8 allottees, then no RERA registration is required. So the IBBI have also got some kind of feedback, and that feedback is the RP to ensure that all real estate projects undergoing CIRP are registered with RERA in terms of section 17(2)(e) of the code. Now, this is the requirement. Practically, I have got some kind of information from the builders that the RERA would only register a project if all other licenses and approvals are in place. During CIRP, maybe there are many such cases where the existing approvals and the existing licenses have already expired. So that would be a great job to be done by the RP to first of all keep all the licenses and approvals on place, and then only RERA will register a project at the request of the RP or extend the registration at the request of the RP. So the proposal in this case is that the mandatory registration to expressly state that the IRP-RP must comply with the provisions of RERA regulations framed thereunder. It is proposed to mandate the IRP-RP to register real estate projects under RERA, or to extend the registration of the real estate projects under RERA wherein the registration is expired or about to expire. So this was one proposal, and the second proposal was that the RP is supposed to operate a separate bank account for each real estate project. No, why a separate bank account? It is not for kind of making expenditures of real CIRP cost. This is for receiving balance amount due from the allottees, making construction expenditure, making payment to the contractors. For that, and also providing reports to the RERA. So this is the objective of the separate bank accounts, not only to incur some CIRP expenditure, because for CIRP expenditure, there can be only one account for the entire CD if the full company is into insolvency. However, in case of project-wise insolvency or project-wise resolution, then the separate bank account would be required. Separate financial statements of the project, legal documents, construction status, identifying potential issues. So all this, in fact, is required to update on the RERA whenever the registration is there. So I believe when this Pioneer Urban Land case was decided by Honorable Supreme Court, the intent was also there that RERA and IBC would coexist. That means RERA compliances and the IBC compliances definitely would be coexisting, and both would be required. However, wherever there is a conflict, then RERA will give way to IBC. That was the very clear judgment of Pioneer Urban Land from Honorable Supreme Court. So based on that, so the proposals that we have now, the IBBI have made two proposals. One is that the registration of real estate projects. Now, this regulation 4D actually is been inserted in chapter 2A, which is the general chapter in the CIRP regulations, that the IRP or the RP, as the case may be, shall register the real estate project of the CD under RERA if the project of the corporate debtor is not registered under that. Second, if the registration under RERA of a project is already there or is about to expire or has already expired, then the IRP or the RP, as the case may be, shall seek extension of the registration of such RERA estate project from the concerned authorities. Then the RP or the RP, as the case may be, shall operate a separate bank account for each real estate project. So Regulation 4D and Regulation 4E is been inserted in Chapter 2A, which is a general chapter of the CIRP regulations. So here, Ankit, in case you would like to say something, because otherwise I'll shift to the other next part.
No, I think we should continue. This is pretty clear. With respect to the questions that I've received so far, so this is Basically, it says for registration with RERA, many other clearances may be required or expired. If a single project is under CIRP, then RP is mandated to obtain only project-wise licenses, whereas normally these licenses will be in the name of company as a whole. I believe with respect to RERA, every project can always has a different license. A company can have multiple real estate projects and they will then have multiple RERA projects. We have also observed that in certain cases where we have been IPs or RPs, there the home buyers sometimes ask the insolvency professional to apply for separate licenses or separate completion certificates for separate buildings or separate structures which are completed or not completed. So I believe that is the complication here.
So good, Ankit. I think we can move to the third proposal, which is execution of registration. Registration means sale deed in case the property is freehold, and if it is if it's a leasehold property, then it is the sublease. So the registration of a sale deed or sublease deed with the approval of the COC during CIRP. That is what the particular proposal
Another
specifies.
important feedback is that what about the fees for registration? So RERA registration also has a lot of fees. So one of the examples is that a 300 square foot project requires 18 lakhs of fees. So will the COC approve this fees to be paid to RERA? That's again a question that Mr. Shiva Kumar has raised. So these are very, very important
These are very
hurdles.
important
This is
observations.
a
Thank
very
you.
important observation that who will pay this fee, because this will be a very large outgo, can be a very large outgo. Even revival can involve a fee.
Yeah. So that's a, I think we should note down and we should give this feedback to IBBI from our side also.
Mm.
And also we would request all the participants to give more feedback because this is a very, very useful. And so, Ankit, can you announce the name of the person who has given this feedback?
This came in from Mr. Sivakumar Amrendran.
So thank you, Shiva Kavarji. So I think we need this kind of suggestion so that we actually can submit all this to IBBI. And like as I had given the suggestion, I have been given the feedback that all other licenses are required. So not only because there are many licenses which actually cost a lot. So those costs also will have to be incurred before we go for RERA registration. So how that money will come? So now when we go to the execution of registration, first of all, there are some conflicting judgments which actually has been discussed in the uh, discussion paper, especially in the case of Alok Sharma and others versus IP Construction Private Limited. And NCLAT has in fact observed that the right of the home buyers cannot be affected adversely in the CIRP, and their interest is to be appropriately preserved and protected within the parameters of IPC, and therefore the order was passed by NCLAT directing the RP to execute sale deed after collecting dues and costs, if any, remaining unpaid, including cost of registration penalty and other incidental charges. So this was the judgment which was there in this is uh, then the feedback that has been received by IBBI is that uh, the there are many transactions where the full payment has been given and the possession has also been given to the allottees, and it is only the one part which is left is the formalization through a transfer document or a sublease document, and some kind of NOC is required when that NOC is not available. So the sum of the units are under technical possession of the allottees, because see the technical possession means that when the builders give a possession to the allottees for fitments. Why the possession for the possession is given for fitment? Because the place has not become habitable because of the sewerage plant, because of the other common facilities which are required for human habitants. So those are not there. So the possession is given for fitments. So then there is a possibility of giving possession on as is where is basis in case they are interested in making their own interiors and fittings. That also is possible. So therefore, in this case, the proposal is that the to facilitate smooth handover of occupied units or where the possession has been transferred to the home buyers, it is proposed to allow RP to hand over the ownership of the plot, apartment, unit, building to them. Further, to avoid delays due to unnecessary holdups, it is proposed that with the approval of the COC, RP may also try to kind of hand over the units on as is where is basis after taking their balance payment as per the original agreement. Now the proposed amendments, they are so there are amendments which are being inserted is 4F in CIRP regulations, and it reads like after obtaining the approval of the COC with not less than 66, there is a specific mention of 66% approval required. One, hand over the possession of the plot, apartment, or building, or any instrument, or any instrument agreed to be transferred under the real estate project where the allottee has performed his part under the agreement and facilitate registration. That is, the RP shall. RP shall do this. Then, secondly, provide an option to the allottee to acquire such units or on payment of balance required to complete the unit during the process, provided that the unit which are under possession of the allottees shall not be part of the assets of the corporate debtor. For the purpose of handing over the possession, the allottees are required to pay all applicable charges or do all the compliances as per the terms of the sale deed or allotment letter or any instrument for transfer and possession of the sale deed which shall not be inconsistent with the applicable laws. This is the kind of proposal that the registration would become possible. And the only hurdle so far is that the uh, one is the that license is not given by the authorities. Now we are not trying. We have to just put a request here to the IBBI that please clarify whether the uh, occupation certificate or completion certificate would be required from the authorities before the RP tries to transfer the possession and registration. Secondly, whether the NOC, which is only required from the lenders, secured creditors, is the only one which is exempted. So these are the two situations. In some cases, the possession is not given because of the occupation certificate is not available. So in case the RP gives possession, RP may be liable for kind of penal action that he has given the possession while the occupation certificate has not been given by the authorities who are supposed to look into the safety of the occupants, fire safety. Like there are many things that has to be there before the possession can be given. So by just writing these two paragraphs, can we really contravene those technical requirements, those safety requirement, fire safety, and other safety requirements, sewerage plants? Can Ankit, we really do that? One thing is that only if the NOC is required from the lender, that can be understandable because they have filed their claim. But how to say that there is a municipal corporation has to give a kind of occupation certificate for a very large building? They also need to give a fire department has to give a fire safety, sewerage department has to give a sewerage plant. So all this cannot be ignored, and RP cannot provide the possession to the home buyers without all this infrastructure. This is what.
One can't give possession and say that okay, this is ready for occupation. There can be safety issues, there can be other issues because of which it's a complex task to get a completion certificate. You need so many approvals, as you just mentioned, fire, safety, architectural confirmations. A lot of things are required.
Yes. Yeah.
All that requires expenses to be incurred for the project to be completed. So again, you come back to the same position that in case you don't have money to complete the project, you normally rely on the resolution plan to be implemented and that money to be invested by somebody. And for that, you need to give that clean slate to somebody.
Right. Right. So, Ankit, we seek some more suggestions from the participants. So now I think we are now to see the COC to examine and invite separate plans for each project. Now, in case we see the existing provisions, the corporate debtor which is associated with real estate has multiple projects at different stages of construction. It is often seen that some resolution applicants are interested only in those projects which are very close to the completion. So the feedback is that in some cases the huge capital is required and not everyone is interested in putting huge capital. So everyone would like to limit their risk. So for limiting the risk, they even propose that we will take one project, the other will take the other project, so that somebody who actually have uh, more infrastructure in a particular area would like to have those kind of projects location wise. So now the proposal is that in view of the foregoing discussions and each project need different treatment in terms of resolution, it is proposed to clarify that the COC on examination may direct the RP to invite separate resolution plans for each project. It would also encourage the association of allottees of a real estate project to bring their own resolution plan to resolve issues. So therefore, the proposed amendment is being made in Regulation 36, capital A, sub-regulation 4 of the CIRP regulation by way of a clarification only. And the clarification which is being inserted in Regulation 36, capital A, is the resolution professional on the proposal and approval of the committee may invite a separate resolution plan for each real estate project or group of projects of the corporate data. So this is the fourth amendment. Now we move on to the fifth amendment, which is exclusion of property in possession of home buyers from the liquidation estate. So the discussion, in fact, has started from the Pioneer Urban Land and Infrastructure Limited, and that was in 2019, and where the Honorable Supreme Court have given the rationale that to safeguard the interest of the home buyers who invest their life savings in purchasing properties, ensuring that they are not left in lurch if the developer faces insolvency. Then is the feedback received by the IBBI. The question has arisen as to whether properties where allottees have taken possession but a registration with any authority or of the transfer is pending are to be included in the liquidation estate or not. In fact, there are some jurisprudence which are conflicting. The first one is the Pradeep Kumar Chaudhary. It's in fact DACCON is the AAA case, and it has been held by NCLAT, and finally it has been held that there was no bar on the execution of the deeds in favor of the allottees, even during the moratorium under Section 14, because as I have said that the all these units, apartments are inventory for the company. It is not an asset. So the Section 14 is applicable on the asset. That means assets which are not inventory. So in the case of Alok Sharma and others versus IP Construction Private Limited, NCLAT has given a judgment in June 22, where they have said that the CD is the owner of the commercial space and has accepted that the possession was with the appellant admittedly. The appellants are allottees of commercial space. Although the CD had handed over the possession of the commercial space to the appellant, admittedly no sale deed was executed by the CD in favor of the allottees prior to the commencement of CIR. The house is so constructed is the business of the real estate, and the sale will actually fall into the revenue from operation. It will not fall into the sale of fixed asset. Hence, this is not an asset. In case of real estate company, it is a recurrent business activity for the company. It is the business of the continuous of the operation. So therefore, the Section 14 is not getting violated. So therefore, the registration of all these houses is a procedural requirement in case of real estate company where the appellant are orderly in possession of these spaces. The right of the home buyer cannot be affected adversely in case the CIRP and their interest is to be appropriately preserved. So this was the judgment where the NCLAT very clearly said that the properties can be transferred because these are not properties, these are inventories. Or for a real estate company, these are inventories. So then in the case of Logix Developers Limited, NCLT New Delhi, in fact, has said the RP is directed to hand over possession of the flat and take necessary steps in furtherance of the same as required under the law to ensure that the peaceful possession of the residential flat is in favor of the applicants. In the case of AU Small Finance Bank versus Coral Infra Gold Private Limited, it was a Jaipur judgment in February 2023, permitted the RP to hand over the flats after compliance of the statutory provisions and allowed sale registration of the flats allowed to the home buyers. The Bikram Chatterjee, the most famous case of Amarpali Group, that in fact decided in 2019 by the Honorable Supreme Court, And in fact, various paragraphs from that judgment my research team has taken, and I would like to read these paragraphs just for understanding what exactly have happened in the Amrpali case. That was also our case. It was a AAA case. The some paragraphs which are very, very important to understand from the Bikram Chatterjee case is that the Supreme Court says we have found that non-payment of dues of the Noida and Greater Noida authorities and the banks cannot come in way of occupation of flats by the home buyers, as the money of the home buyers have been diverted due to inaction of officials of Noida and Greater Noida authorities. They cannot sell the buildings or demolish them, nor can enforce against home buyers leased land project in face of the cases. Similarly, the banks cannot recover money from projects as it has not been invested in projects. Home buyers' money have been diverted fraudulently. Thus, fraud cannot be perpetuated against them by selling the flat and depriving them of hard-earned money and savings of the life. They cannot be cheated once again by sale of projects raised by their funds. Noida and Greater Noida authorities have to issue the part completion certificate, as the case may be, to execute tripartite agreement and registered deeds in favor of the buyers or part. Completion of the buildings, as the case may be, or where the inhabitants are residing within a period of 1 month. That was the order in the case of Vikram Chatterjee. In the case of Tharuvai Ramachandran Ravichandran, the RP of JB Homes Private Limited, the NCLT Chennai, have also held. Thus, in order to protect the interest of the home buyers and also in order to complete the justice, keeping in view the intricate and unique facts and circumstances of the present case, we are of the opinion that the project GRT grant 71 flats are sold should be kept outside the purview of the liquidation estate. Outside the purview of liquidation estate, excluded assets. Now, this was the decision of NCLT Chennai in September 2023. And these particular 71 flats were kept outside the liquidation estate, understanding the facts of the case. However, in the case of Samruddhi Realty Limited, the NCLAT has taken a different view. In the case of Samruddhi Realty Limited, the sale agreement with the home buyers or with the allottees that was entered in 2011, had taken the possession of nearly completed villas in 2016. So the possession has been taken in 2016. Now, in this case, in the case of Samruddhi, the allottees filed an application to exclude the property in their possession from the liquidation estate and for its registration in their favor. Despite the fact that full payment were made by these allottees for these properties which were in the possession of the NCLT ruled in May 23 that since no sale deed was executed, the property cannot be excluded from the liquidation estate. This was also affirmed by the NCLAT, highlighting that no security interest was created in favor of the applicant, and without a registered sale deed, they had no ownership right, thereby denying them any relief. And my understanding is that even if the security interest has been created, just having a security interest doesn't mean that the assets can be excluded from the liquidation estate. Second is the proposal, the proposal which is there before us for giving our comments, that the amendment that they're trying to make is in Regulation 46 of the liquidation regulations, exclusion of certain assets from the liquidation estate. For the purpose of Section 36, Regulation 36, Section 36 4E, wherever an allottee as defined under Clause D of Section 2 of RERA is in possession of the unit, it shall not form part of the liquidation estate of the corporate debtor. That is in section. But then Regulation 46A is being amended by referring to the section. So Ankit, we have finished all the suggestions, the discussion papers and we have now some of the judgments that we can discuss. And because see what we want to say in the case of in real estate cases, that the primarily what kind of disputes are pending in real estate cases. One is that the delayed claims from the allottees. That has been handled by the IBBI by regulation, that it is the duty of the RP to accept the resolution, accept the claims till the till the issue of the RFRP, and even till later when the 7 days before the meeting of the COC, in which the voting is started or voting is proposed. That issue has been resolved. Now the other issue is that the uh, like kind of whether this landowners have any security interest in case they are unpaid, and whether the home buyers have a security interest in case they are unpaid. So because the home buyers always fear that they are only unsecured, whereas the lenders are secured. And on the other hand, the landowners, they are also scared, like their money is not yet paid, their share in this space is not yet given, and how they can be considered as an operational creditor. So these are some of the judgments which actually will provide some kind of understanding further, so that what amendments are required. So this is a judgment which is given in September 2023. It is Naresh Sundarlal Jain versus Udaipur Entertainment Private Limited. This case is, of course, it is a High Court of Mumbai case, High Court of Bombay, and in that case, it is said that the any one person who was an unsecured creditor without any allotment agreement, he actually approached High Court of Bombay that he actually should be considered as a home buyer, or he should be considered as an allottee as per section 331. So this is the various facts of the case. I think the facts, I should not say facts, because see, there are three issues in this case. One, whether he has the jurisdiction, whether the High Court of Bombay has the jurisdiction, that was one issue. And the second issue was whether this particular person who has given unsecured loan to the corporate debtor, whether he actually can be considered as an allottee. So while rejecting the petitioner's demand, while rejecting the petitioner's claim that he should be considered as an allottee, the High Court has said that we have seen that he means that the petitioner has no security interest in the assets of the company as per section 331. However, the Supreme Court, the High Court is saying that the allottee, had he been an allottee, had there been an agreement, then he would have been considered as a secured creditor, or it would have been considered as a security interest under section 331 of the IBC. So this judgment is the first judgment which actually have recognized the definition of security interest under section 331, and have said, although by a passing reference, or although for the sake of rejecting the petitioner's demand, that he does not have a security interest. But that means in case we have an agreement, then the home buyers will have a security interest. And in case the home buyers will have a security interest under section 331, that actually would apply to all home buyers. So therefore, it is a case where the home buyers can be considered as a security interest based on the definition under section 331, section 333, section 334. So this is something which is a food for thought, which I am saying that the home buyers can also be considered as security interest. Similarly, there are lenders who are secured creditors, and the landowners also should be considered as an operational secured creditor. Secured operational creditor, because see, they have not given a loan, but their transaction is because they have a lien on their property as unpaid, because they have not yet transferred. The title is not yet transferred. In the case of sales of goods, that we see that the title is transferred, but in this case, the title is not transferred. Sorry. So, Ankit, what do you say in this scenario? First judgment has come where some court has said that the allottees can also be this is a security interest by way of an agreement. I I have written an article in 2018 which was published where I have said that the home buyers are secured financial creditor under section 58F, and also because of the definition of security interest under section 330, 331, 333, 334. So this all needs to be argued before a court, and also the landowner. So in case home buyers, the secured financial creditors and the landowners, they can actually share the assets of the company and try to find out a solution. I believe that actually would resolve most of the real estate cases. So then, like in this was a India Bull ARC Limited versus Ram Kishore Arora, because this is a case of Supertech, which was finally decided by Honorable Supreme Court on 11th of May 2023, where in fact when the Supertech's insolvency was initiated, and then finally NCLAT reduced it to a project-wise insolvency, and then there were many applications were made to Honorable Supreme Court, saying that the NCLT does not have power to initiate CIRP against one project of real estate company. So that was the power which was challenged. But finally, Supreme Court says that considering the facts of the cases, without even discussing the merits and the legal issues, the Supreme Court said that it is the balance of convenience and likelihood of irreparable injury shall to be taken into account. And based on this, all these applications were dismissed, and therefore the project-wise insolvency of Supertech is continuing. This is all from our side. Ankit, would you like to add, or we would like to answer some of the questions? And because we have time, so we should actually ask the time from, we should ask some kind of
We have quite a
question.
few comments and rather questions also. So one of the interesting judgments that Santosh ji wants us to have a look at is the judgment of Supreme Court in the matter of Vishal Chalani and others versus Debashish Nanda. So this is a judgment which is the latest Supreme Court judgment which Santosh ji is asking us to talk about.
Vishal?
Vishal Chalani
Okay.
and others versus Debashish, Debashis Nanda. Debashis Nanda.
Okay.
So
So
this we
what is,
can have a look. So if Santosh ji can share with us
we'll
that
find out Vishal Chalani and versus what?
versus Debashis Nanda.
Okay. So what is NCLT? NCLT, what exactly is this?
This is Supreme Court.
Okay. Hmm. So we'll find out this. And any other suggestion for the purpose of implementation of these regulations?
Then I will just take up all the comments one by one, and we can discuss those. Will the Sharma ji says that will a housing finance company bank having given loan be treated as a home buyer if there is a tripartite agreement with home buyer, developer, and lender, though no charge is registered? So no, they can't be treated as a home lender because they have given a loan. We are talking about this issue where there is this subvention scheme, rather a tripartite agreement where the lender and the developer sign an agreement with the home buyer, and there the home buyer gets the loan in his name, and the developer there, of course, gives certain guarantees to the lender. So here the home buyer, of course, continues to be the home buyer, and he files a claim as a home buyer. The lender can file a claim with respect to the guarantees given by the developer against the same flat. So rather, we had given a legal opinion to one of the PSU banks in this regard, and they had subsequently filed claims with the resolution professionals regarding, their claims in a tripartite agreement.
Yes.
So, so this is what is this about. Then next is Santosh ji is saying that in 2020 IBC was amended for RERA registered CIRP and project-wise CIRP of real estate projects. Also, home buyers or secured FCs. If security interest is created in apartments, can it be part of liquidation estate? Home buyers presently under the law, many people
No.
read that they are not secured financial creditors. So there is no interpretation so far that secured financial creditor status is also with home buyers. Rather, they are normally treated as unsecured financial creditors. And
I also don't
the
think that the project wise there is any amendment of initiating CIRP project wise.
I think it was proposed in the discussion paper only. It has not come out. I remember reading this project-wise discussion. Anyway, Supertech is an example where Supreme Court has said that project-wise CIRP can happen. So through jurisprudence, that is happening.
Yeah.
But yeah, that's the case. With respect to whether the security interest is created on apartment, can it be part of a liquidation estate? I believe many assets which are belonging to the corporate debtor can continue to have a security interest and at the same time be part of the liquidation estate. And I think that's the 90% of the cases that is the case, that the assets
All
belonging to the CD.
all assets of secured creditors will form part of the liquidation estate.
Yes, so that's how it is. Unless and until then, you kind of have that caveat that if the creditor says no, I will not allow this to be part of the security to the part of the pool of the assets, liquidation estate, then that's a different story. Then we have Naresh Agarwal ji. He says, Sir, project has been handed over to RWA by the builder, but IBMS deposit has not been paid. If RWA moves in NCLT, please advise under which section will it proceed, section 7 or 9. IBMS is carrying interest also. So if there is a maintenance related security which is submitted by individual home buyers to the builder and the builder is not releasing this to the RWA, I believe it is a deposit. It's in the nature of deposit, and if there is a court decree with respect to the builder paying this amount to the RWA, I believe the RWA will get a status or the individual allottees will
It
get
is
the
a
status of an
deposit, so
operational
it's a
creditor.
Section 7 application.
The Section 7 application. So Section 7 application is what it will be. So
Yes.
that's the answer to your question. Then Pankaj ji is saying, what happens to registration of flats executed by suspended directors where the buyers are not aware? Can we use shelter of intra-wire concept? So, so basically, those allotments which are executed by the directors in lieu of some credit balance or in lieu of some balances. So there, when we process the claims as resolution professionals, we do become careful that those flats or those units which are allotted in this manner are normally tagged differently, so that if there is any way in which these allotments can be justified to be related party transactions or preferential transactions, undervalued sale of asset transactions, in those cases we can try and reverse that process. But if there are valid documents, everything is complete, the transfers have also happened at the market price, then it becomes difficult to cancel these allotments on a post date. What happens to the debt of an FC where the exposure or to a specific project is lower or nil and there is no resolution plan for resolution plan received for other projects of a CD? So basically, we talk about disbalance in the different projects. One project might be profitable, other project might be having a deficit. This is one of the reasons why we say that the resolution plan should normally be for the entire company as a whole, because there are, almost in all the cases, there is this imbalance that one tower is constructed at a higher level, the other is at a lower level. So, in case at that point in time you say that, okay, it was your luck that your tower got completed and therefore your contribution is lesser as compared to the other person whose flat was not built, because intermoney between the different towers, different projects is very common in real estate, that you use the funds for one project for another project. This is what used to happen before ERA came in and the escrow account systems were put in place and all that.
Then suggestions are not coming. I think these are all further questions. Like we wanted to have some suggestions for how to revert on this IBBI discussion paper. That was the objective today. So I still feel that the suggestions
For
should be.
any suggestions, no, I find mostly these are questions only.
Okay, I think then Ankit, we can conclude that, and I would see like we have today one seminar at Yes Bank building in Noida, and all the insolvency professionals or advocates are invited to that. It is free of cost, and the sponsorship for the space and tea coffee has been given by Yes Bank. So in case anyone can participate in person, I believe it should be welcome from our side. So thank you very much. And this subject is over as far as the discussion papers are concerned. We will look for a new subject, or rather we would ask suggestions for some more subjects on which we can create our research and we can actually bring our next episodes. Thank you very much for being with us.
Thank you. Thank you, everyone.